All right, please sign into the attendance. Okay, and here is the link to the class notes for today. Okay, we'll start in a minute. Okay.
Hey, Professor.
Yes.
Your co-author is right. It's pronounced Laughlin.
Laughlin? Okay, thank you.
You're welcome.
Oh, he's usually right, and when he's wrong, it's my fault.
I had a neighbor named Laughlin.
You know, people pronounce the same name different ways, so I've heard it both ways. I've heard Laughlin, like, you know, the Full House actor, isn't she? She pronounced it Lori Loughlin, like, no, just went to jail. So, Lori Loughlin? I don't know. Doesn't matter. All right. Any other questions before we get started? I appreciate that, lady. All right. Let's get started then. Today we are continuing our discussion of enumerated powers. And I'd like to give a brief sketch of where we started from. And that might help us work our way to the present. So if you go to in your supplement, page 22, I keep going back to the same document, but it does help to describe our history. We are talking about the doctrine of implied powers. In every case that you think is about the Commerce Clause, Congress is also relying on a power lurking in the background, which is a necessary and proper clause. This is an independent power, which allows Congress to carry into execution its foregoing powers, such as the commerce power. We say a case like McClung v. Maryland, DeWitt involving the oil, Hepburn v. Griswold, and Knox v. Lee, which involved Legal Tender Act. And all these cases from the 1800s sort of ping-pong back and forth about the scope of federal power. But starting in the late 1800s into the 1930s, there was a progression of just a broader and broader scope of implied powers. E.C. Knight was really the last major case that pulled back on Congress's powers. That case established what came to be known as the direct effects test, where Congress could only regulate economic activity that had a direct effect on interstate commerce. In that case, the government tried to regulate the manufacture of sugar, but the manufacture of sugar maybe had an indirect effect on interstate commerce. It was not direct. We have Champion versus Ames, which involved the transportation of lottery tickets from state to state. In that case, we actually had commerce among the several states the court held. So that law was permissible. In Hammer versus Dagenhart, you had a case involving the shipment of goods made with child labor. Now, you might think that that has a sufficient connection to interstate commerce, but the court says, no, it's indirect, right? They're not really regulating the shipment of goods. What they're actually regulating is local wage conditions, the local manufacture of child labor goods. But then we get to the 1930s, and things turn fairly quickly. In 1935, we have Schecter Poultry. This case holds that the local slaughter of chickens in Brooklyn is not interstate commerce. This was the last major defeat for the Roosevelt administration, and the last really big case where the court found a violation of Congress's commerce powers. We get to 1937 with NLRB versus Jones and Laughlin, or Laughlin, however you say it, Steele. And in this case, the court upholds a regulation of local labor conditions because the company had a nationwide presence and did ship goods across state lines. But Jones and Laughlin Steel relied on the direct effect test. Then we go to 1941 with the United States against Darby. This involved setting the wages for lumber workers. And here the court formally abandons the direct effect test. The court overrules Hammer expressly. And the court adopts what's known as the substantial effects test. Substantial effects test. If local economic activity has a substantial effect on interstate commerce, then Congress can regulate that local activity. When you see this phrase, substantial effects, you should have little flags to go off in your head. Ding, 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 ding. We're talking about the necessary and proper clause. The court isn't saying that the local activity is interstate commerce. That's not what's going on. It's that this local activity is not interstate commerce, which is precisely why you need the necessary and proper clause. You can regulate this local activity through necessary and proper powers. Why? Because this local activity has a substantial effect in interstate commerce. Okay? Then we get to 42, the following year, with Wickard v. Filburn. This was a case about the farmer growing his wheat. Wickard v. Filburn builds upon Darby. So Darby introduces a substantial effects test. Wickard builds upon that and introduces what's called the Aggregation Principle, or the Aggregation Doctrine. You'll see it both ways. The Aggregation Principle says that when we're doing necessary and proper clause analyses, we're not only looking at the output of a single farmer, right? We're looking at an entire industry. That if all of these farmers grow local wheat and they don't buy wheat from the market, in the aggregate, all of their local activity in the aggregate would have a substantial effect in interstate commerce. Does there need to be proof or evidence that there are millions of local farmers growing wheat? Of course not. That's not necessary. Instead, all that's required is that Congress has a general notion that this could work. That there's some rational basis to believe that local farmers could pool together their wheat and not buy it on the interstate market. Okay? Once you get to 1942 with Wickard, Congress's powers are pretty broad. There are going to be very few local economic activities that are beyond the scope of the federal power. Now, if you notice, I keep saying economic activity, and I'm quite deliberate there. You'll see why in the next class. But all these cases do involve some form of economic activity. Working a lumber yard, growing wheat, running a hotel, running a restaurant, barbecue joint, right? All these cases involve some form of economic activity, which either independently or in the aggregate might have a substantial effect in interstate commerce. Okay, that's about 150 years of history. I think I summarized questions on that. Questions on that history.
Yes, please.
Is that Lainey?
Yes, sir. I'm sorry. I didn't raise my little blue hand. I can't find all these things at the same time.
That's all right.
On the Schecter Poultry case, please, what was your quick summary? Was the last violation of Congress's
Commerce powers.
Thank you.
Yep, my pleasure. What's it say behind you? Is the law? I can't see what it says behind you.
It's the preamble to the National Association of Realtors Code of Ethics under all of the link.
Oh, the land. Okay, there it is. Oh, so the L. Okay, very good. Oh, it should be my property class. I'm sure that's very useful now. Okay. Thank you, Lainey. Let's try the question I posed to you last week about the coal mine, and let's take this up to 42. I think this is this question will help, I think, reinforce in your notes how these doctrines shifted year by year. So I think in the last class I asked you through 31. I can't remember, but anyway, we'll start here with 35. So this is your question. Congress enacts a law to regulate the wages of workers at coal mines that ship coal across state lines. Congress finds that the moral conditions of the mines are low and the safety conditions are poor. Is this statute constitutional? Yes or no? And the year is 1935. Okay, another 15 seconds. And I'll be calling on, I don't know who's next. Whoever's next, please raise your hand.
I believe it's me.
Who is that?
Fry. Evan Fry.
Okay, Fry. All right, let me just stop the polling, and I'll call on you in a second. Okay. All right. Fry, what's your answer here?
I picked B, no.
Okay,
because,
tell me why.
Under Schecter, during that year, they were still applying the direct effects test. So.
Very good. And I love the way you answered that question. You gave me the case name and you gave me the relevant test. That's very good. What's the direct effect test, please?
That Congress can regulate local activity if it directly affects interstate commerce.
Okay. So the answer here is false. That's correct. Or no. This would be an unconstitutional law. About 70% of you got that right. I think that's very good. All right. Thank you, Evan.
Yep.
At 35, we're still applying the direct effect test. I said it wrong. You're applying the direct effect test. Okay. Now we go to our next question. Now you move on to 1937. Same question. Is the statute constitutional or not? Okay. Another 20 seconds. Okay, another 5 seconds. Okay, and Taylor, you are up next. You there, Taylor?
Yes, I'm here.
Okay. What is your answer?
I put yes.
Okay, you said it's constitutional.
Yes.
Tell me why.
Because Laughlin Steel Corp.
Very good.
The direct effects test, but it expanded.
Good.
To where if like labor was directly affecting commerce, which here lower wages would have made steel cheaper in certain places.
Oh, very good answer. I like the way you asked the question, right? Jones and Laughlin Steel expanded upon expanded upon the direct effect test, right? And it says if the local commerce has a close relationship to interstate commerce, it's enough. And here the question says that they're shipping coal across state lines. So is that enough, Taylor? Under Jones and Laughlin Steel?
They say yes.
That's right. Okay, very good. Thank you, Taylor. All right, now question number 3. The year is 1941. Is the statute constitutional? They should be getting easier as we go down the list. From here on out, the answer should be pretty obvious for question number 3. Okay, oh well, 50 answers in. Oh boy, I think this might be a record for our class. 5 more seconds. 100. Very good. Rarely ever do we get 100. Keep it 100, right? Very good job. So here, in 1941, we have the case of Darby. And Darby brings in a direct effect. I'm sorry, I'm doing the other one. Darby brings in a substantial effects test, which asks if this local economic activity has substantial effect on interstate commerce, then Congress can regulate it. Shipping coal across state lines has a obvious effect on interstate commerce, right? It's not direct, but it's substantial. See the difference between having direct effect versus substantial, right? It doesn't have to be closely related. Just in general, is there an effect that's felt? Of course there is. All right. I don't even have to ask the number 4. I think you all know at this point. I think you're all 100%. In 42, you have Wickard. Wickard v. Filburn was the wheat case. Even if, I probably tweaked the question, even if the coal mine did not ship their coal across state lines, I still think that statute should be unconstitutional. I still think the statute should be constitutional. Because if all these local coal mines together stop shipping coal, that may affect prices in the market. So once you get to 42, my friends, the answer is almost always yes. There might be some no's along the way. We'll do them maybe in that class, but the answer is pretty much yes. Okay. Good. Very good. Okay. Questions on that introduction? You guys did pretty well on this one today. Anything? Okay. All right. Let's move on then. Today's topic discusses, or at least begins with enumerated powers on the Warren Court. When I say the Warren Court, what do I mean by that? Historically, the Supreme Court is labeled by whoever the Chief Justice is. So you have the Marshall Court, you have the Chase Court, right? And then in the 1960s, you have Chief Justice Earl Warren. Earl Warren was the former governor of California, but he's best remembered for his role as Chief Justice. He was a Republican appointee by President Eisenhower, but he proved to be quite liberal. And in the 1950s and the 1960s, the court presided over this explosion in civil rights laws. Now, people often think that the Supreme Court was the one pushing the expansion of civil rights, but the court was more or less trailing behind. The branch of government that took the lead was actually the legislature and the executive as well. We'll study later this semester the school desegregation cases, but we'll find that what really desegregated schools was not judicial decisions, but the executive branch sending in armed guards to desegregate schools, or the federal government providing funding for schools that integrated. That is what really made the difference. It wasn't Brown. Brown had very little effect on the real world. But today we're not talking about school desegregation. We're talking about segregation in places of public accommodation. So I need to give you a little bit of background about this first. In 1964, Congress enacts the Civil Rights Act. This was a very significant law. And Title II of the Civil Rights Act prohibits discrimination on the basis of race in places of public accommodation. Now, what's a place of public accommodation? It's similar to the notion of a common carrier, which you probably studied in contract or torts. It's not exactly the same, but there's a lot of overlap. So we're talking about hotels, restaurants, theaters, bus stations, different places that people generally have access to. This was a federal law and not a state law. Virtually everyone agrees that states have what's called the police power to prohibit segregation in these sorts of common carriers, these places of public accommodation. But the question here was whether Congress, the federal government, had this sort of power. Now, the Civil Rights Act of 1964 was not the first attempt of Congress to prohibit segregation in public accommodations. The first attempt actually came almost 100 years earlier. 100 years, it's a long time. With the Civil Rights Act of 1875. The Civil Rights Act of 1875. This was a law passed in the wake of the Civil War. And this law made it a crime to exclude people on the basis of race from various public places like theaters and hotels and other accommodations. Now, why have none of you ever heard of the Civil Rights Act of 1875? The reason why is that the Supreme Court declared it unconstitutional. Never heard of that case, did you? The case was called the Civil Rights Cases. The Civil Rights Cases. The Civil Rights Cases was not based on Congress's commerce powers. Instead, the case turned on the 14th Amendment, which we'll study the second half of the semester. I'll give you a brief preview. The 14th Amendment gives Congress the power to enforce certain civil rights laws. I'll leave it there for now. The specifics are not important. But the court says that Congress did not have the power to regulate local businesses, right? These are local businesses. These are not state actions. So Congress says this is beyond the scope of federal power. Now fast forward almost 80-something years to the Civil Rights Act of 1964. Here, Congress tries to once again regulate local businesses. They rely on the 14th Amendment, but that argument's sort of put to the side and only Justice Douglas seems to care about it. We can talk about it later if you'd like. But the primary focus of the case is not on the 14th Amendment. It's on the Commerce Clause and necessary and proper, right? They don't ever mention necessary and proper, but it's there. Trust me, it's there. And so the question becomes, can Congress prohibit discrimination in these local places of accommodation through its Commerce Clause powers? And we have two test cases. What's a test case? A test case is a legal challenge brought to test the validity of a law. So here we have these two test cases brought in 1964 by segregated businesses in the South. We have the Heart of Atlanta Motel, which is, as the name suggests, Atlanta. And we have Ollie's Barbecue, which is in Birmingham, Alabama. I have lots of trinkets in my office at school, which I don't ever go to anymore. But if you ever come to my office, I'll show you some of my trinkets. I actually found, I have lots of eBay alerts, but I actually found on eBay a matchbook from the Ollie's Barbecue, which was made in Atlanta, which perhaps provides proof that they were engaging in interstate commerce. I also have a case of barbecue sauce from the Ollie's Barbecue, which no longer exists. I've never actually tried it. It's probably very spoiled at this point. It's quite old, probably a decade old. But I have all these sort of trinkets from these various cases. Another funny story, the Heart of Atlanta Motel was in downtown Atlanta, and there was a picture, a very famous picture of this hotel where there was a swimming pool, and they put a speedboat inside the swimming pool. And they had this like little, she was some sort of pageant, like a beauty pageant winner, sitting inside this boat inside the swimming pool. It was a very famous picture. And I showed it one year. And after class, this one student goes, that's my aunt. And she never knew where the picture was from. She'd always seen this picture, in her family, whatever. And then it turns out that her aunt actually was a model, and she'd done a photo shoot for the Heart of Atlanta Motel. Go figure. Although the weirdest one I ever had was later this semester we'll talk about the school segregation cases. And in the South, a group called the White Citizens Council built a number of segregated schools. They were called council schools. Right, council schools, that's what they were called. And then one student, she raises her hand and she says, my mom went to a council school. I never knew what it was. And apparently the mom was in kindergarten there, had no idea what a council school even was. And then the student went home and told her mom, she's like, that's what a council school is? She just had no idea. And then she had this, she got freaked out. So very often when I mention stuff in class, it sort of hits closer to home than I expect. So if you have any of those, you can let me know, maybe after class or in the chat. All right, any questions so far? All right, let's try this. See how this one works. Question number 2, short answer. I want you to try to answer in one sentence. Why can Congress prohibit segregation in the Heart of Atlanta Motel? Try just try one sentence. See how this works. We'll see how you guys do. I'm not going to grade these now. I'll look at them later. But I want to just see how you guys doing this. Okay, let's see. All right, another 10 seconds. Okay. All right, I'm going to stop it there. All right. Now I want you to do the next question. Question number 3, which is a little bit different. Why can Congress prohibit segregation in Ollie's barbecue restaurant? Jose, I'll get to you in a minute. I'm sorry about that, Jose. Everyone else is there, so try reloading your app maybe. Or if you're having difficulty with the phone version, try it on your computer. Because I have like 40 people. All right, another 10 seconds. And I'm sorry I have to rush you on these, but just we don't have time to let these ones run forever, unfortunately. Okay. Okay, very good. Stop it here. All right, so who's next? Alexandra's next?
Yes.
Okay, Alexandra. What were the facts in Heart of Atlanta?
So here, the owner of a motel refused to accommodate Black people and didn't let them in his hotel at all. And he said he was arguing that Congress had kind of overreached its authority in enabling the act to make him not discriminate against them.
Very good. Okay. Now, let me ask this question a little more precise. What was the connection between the Heart of Atlanta Hotel and interstate commerce?
Wasn't it that they were 70, I think it was 70% of its guests were from out of state. So they weren't entirely local.
Huh, okay. 70% of their business is from out of state. Where was the hotel located?
In Atlanta, Georgia. It was close, I think, to a highway or something.
Okay, let's go to the interstate. So let's just be very clear here. Was the regulation in this case designed to... I'm sorry. This is going to sound like a weird question, but I promise it's not. Did the hotel rooms ever move between states?
No.
Okay, no, obviously, right, not. Okay, so Alexandra, is this case similar to our previous cases where stuff was shipped across state lines?
No.
Okay, no.
It's similar in that it's applying the substantial effects test.
Ah, good. Okay, good. Vanessa, are you here?
Yes.
Okay, so Vanessa, this case, Heart of Atlanta, is not like, Darby or Jones and Laughlin or even Wickard, because nothing is getting bought or sold across state lines, right? What is the activity that Congress is regulating?
They're saying it's the people that move.
Oh, good. You answered like 3 questions down the road, but I'm going to get there. You saw where I was going, which is good. But what's the exact activity that Congress is regulating here?
Interstate commerce.
With respect to the hotel, what's the exact activity that the hotel is doing that's bad?
Not letting people stay there.
Right. Okay. Is that in any way an activity that crosses state lines? I know this sounds really stupid, but just the decision to say, you come to my hotel and say, no, I'm not giving you a room, right? Is that in any way commerce among the several states?
No.
Okay. So you answered my question already. Where is the interstate commerce here? Is it the hotel? Is a hotel engaging in interstate commerce? What is the interstate commerce?
It's the people that...
The people. Wait a minute. Wait a minute, Vanessa. Are you telling me that people are commerce? Is that what you're saying?
That's what they say.
Is that a little bit weird?
It sounds a little bit weird.
Yeah. Why does it sound a little bit weird? Why is it just like a little it's like, huh? How can that be?
I guess I typically think of interstate commerce as items and not really people.
Yeah. Thank you, Vanessa. That's right. And whenever I teach this case, someone always raises their hand and say, "Wait a minute, can that be right? That people are commerce?" And there's a not very good history here. We don't talk about slavery too much in the first half of the class, but it is relevant. One of the initial applications of the Commerce Clause involved the movement of people who were enslaved. One of the reasons why Congress could regulate slave trade was at a commerce power. So there actually is a pretty long-standing, deeply rooted argument that the movement of people was commerce. And the fact that in this case it's a movement of African Americans as commerce, it's a very strange connection that explains, I think, why Justice Douglas wrote the concurring opinion he wrote. But I think Vanessa is exactly right. In this case, in Heart of Atlanta, sure, the hotel, marketed out of state. Sure, they were near the hotel. They were near the interstate highway. But the actual commercial activity, the actual interstate commerce, was the people driving, down the highway to the hotel. Now, Samuel, are you here?
Yes, sir.
All right, so Samuel, let me ask you a question. In what way did the Heart of Atlanta Motel affect that interstate commerce of people? How did the hotel's policy affect this interstate commerce of people driving down the highway?
I believe that the court was basing its opinion on it's affecting their travel because if they would have a place to stay.
Okay, very good. Right. Okay, thank you. That's what I'm looking for. Did anyone see the movie The Green Book? It came out about a year or two ago. The premise of the movie was you had an African American musician who wanted to tour the country, and he brought along with him a white driver to help him, navigate parts of the South and keep him safe. But the Green Book was a publication that was well known. If you just Google Green Book, you'll see pictures of it. This was a publication that listed all the businesses that were safe for Black customers to visit while they traveled. So let's say you were driving from point A to point B, right? What gas station would serve gas to Black customers? What restaurants would see Black customers? What hotels would allow Black customers? What barbershops? What garages to repair your car? Right? Even the most basic things you could think of. If you were traveling from one state to another, and your car breaks down, and you can't find a garage that will service your car, okay, you're stuck, right? So the court's reasoning was premised upon this idea that the people themselves were the commerce, and that barriers to that commerce moving, obstructions to that commerce moving, actually were problematic. And Congress could take steps to eliminate those obstructions on commerce, right? They could take steps to eliminate those obstructions on commerce. So if people were traveling from New York to Florida, for example, they would need to know they could stop at a hotel that was on the way. Lainey, I see your hand in a second. I'll get there in a second. If you actually pull up the Houston Green Book, just Google it, you'll find it. It was a national publication. Some of the businesses I think are still around in Houston that were listed upon this, listed in this book. But the court specifically references this Green Book. Lainey, go ahead.
So was the court really saying the people were the commerce, or were they saying that the people were participating in commerce and contributing to commerce? The
people who were moving were the commerce. It's not that the people were buying stuff along the way. It's the mere movement of the people is the commerce among the several states. Remember Marshall said intercourse, that word he used, right? Navigation. The commerce was, the people were the commerce. It's like soil and green, right? It is the people, right? It's the commerce. Does that make sense, Lainey? I don't know if
yes, I just have to accept that that's how the court saw it.
It's a strange, it's a very, and I'll get to Justice Douglas's concurrence in a little bit. But it's just a very strange rationale that the basis for these federal civil rights laws is holding that the people themselves are commerce. The court doesn't acknowledge that sort of irony, but that's the basis for the holding. Now, when we get to the Katzenbach v. McClung, the Ollie's barbecue case, this sort of just goes out the window. It doesn't matter, right? It doesn't really matter that people are commerce. Right, but that's the holding here. Yes, Macy, go ahead.
Do you think that, in this specific situation, the court called commerce
was more just like a means to an end for them to get the outcome that they wanted with the civil rights laws, without having to admit that they really didn't fit.
Well, look, Macy, let me ask you a follow-up. I don't want to jump too far ahead, but in the next case, in the Ollie's barbecue case, did it matter whether the customers were traveling from out of state?
No.
So did they really need to have this holding at all? I think you froze. The answer is no. I think Macy would have gotten that in a second. Right. I mean, it's always a dilemma in this class. You know, why do judges reach certain conclusions, right? Why do they address things a certain way? Look, there were laws about prostitution. There was a federal law that made it a crime to transport women across state lines for immoral purposes, which is prostitution. This is the Caminetti case, which is cited. And the court held in that case that the transportation of women across state lines was commerce. Now, I suppose, I'm going to get canceled now, but selling women across state lines perhaps was commerce in ways this perhaps isn't. But there were cases that the movement of people could be subject to a commercial definition. But yeah, I teach them in this order: Heart of Atlanta first, and Katzenbach second, because Heart of Atlanta is this entire convoluted analysis of people traveling and commerce. In the next case, okay, there are no interstate customers, doesn't matter. Still Congress can regulate it. So it didn't really matter, which makes this holding a little bit harder to swallow. Okay. Everyone with me so far? All right. So let me summarize a bit for the majority. I'll get to the concurrence in a moment. The court here purports to apply McCulloch v. Maryland, the Chief Justice's framework. And the court says, and let me just read this passage to you. The court says, how obstructions in commerce may be removed, that is, what means are to be employed, is within the sound discretion of Congress. Now, what does that mean? The means to be employed. If Congress identifies that these segregated hotels are creating obstructions to commerce, then Congress can choose what means are necessary to eliminate those, right? How to go about addressing those problems. The court writes, there's only one restriction on this power. The means chosen by Congress must be reasonably adapted to the end permitted by the Constitution. Again, the means chosen by Congress must be reasonably adapted to the end permitted by the Constitution. This phrase, reasonably adapted, is a standard that's very differential. You know, the court's not going to second guess what Congress does. Is it reasonable? Sure. Is there a problem of people traveling interstate commerce not being able to use hotels? Yes. Is it reasonable to require the hotels to accept all customers regardless of race? Yeah, it's reasonable. That's it. The court's analysis ends right there. All right, questions in the majority from Heart of Atlanta. Questions in the majority from Heart of Atlanta. All right, let me talk for a little bit about Justice Douglas's dissent. Or not dissent, concurrence, I'm sorry. Justice Douglas seems to be a little bit hesitant to rely on the Commerce Clause because it's very fact-bound. He's like, well, in this case, you know, what happens if you have a restaurant that grows all the produce locally, you know, and doesn't use any tools from out of state, and doesn't service any out-of-state customers? Could Congress reach that? And Douglas would just say, we don't need to deal with these sort of specific Commerce Clause analysis because the 14th Amendment gives Congress the power to eradicate certain civil rights violations. We'll return to the civil rights cases in the second half of the semester, but just make a note in your outline. When we get to what's called Section 5 of the 14th Amendment, we'll come back to this issue later. Questions in Heart of Atlanta Motel. Questions in Heart of Atlanta. If you ever go to Atlanta, I think it's a Hilton Hotel now in downtown. You can see it there, so it's a much bigger hotel. I think the hotel's long gone. Yes, Stuart, go ahead.
So in this one, because I know Douglas is saying that they should use the 14th Amendment, but I'm wondering how would that have affected the consequences if they had gone for a 14th Amendment rather than the Commerce Clause? So I feel like because the Commerce Clause is fact-based, it's a much easier case to get through and factually find that they can't segregate these restaurants.
Yeah. Thanks, Stuart, for the question. I think you're actually next, by the way, on the roster, so I'll call on you in a minute. We'll do the 14th Amendment. I'm sorry. We'll do the 14th Amendment in the second half of the semester. But the short answer is the 14th Amendment may allow Congress to prevent racial discrimination and perhaps gender discrimination. It's not so clear that other forms of discrimination are also covered by it. So I think the commerce power in some regard is broader than the 14th Amendment would be. But the court just doesn't want to deal with it for reasons that will become clear later this semester. Yeah, it's always a tricky part. Randy and I were working on the 4th edition of the casebook now, and we're deciding where to put cases, and we actually are moving some stuff around. The connection between enumerated powers and the 14th Amendment is tricky. We're going to actually rejigger a few cases next semester, the next book, which will be published long after you've graduated. Okay. Stuart, let's talk about Katzenbach and McClung. What were the facts there?
So this is a family-owned restaurant in Birmingham, Alabama. Mm-hmm. And they have a capacity to seat 220 customers. They cater mostly to family white-collar workers, and they have a takeout service for African Americans.
Okay. Well, it wasn't just they had a takeout service. Did they serve black customers?
Well, yeah, but only takeout. They can eat at the restaurant.
Right. Okay. It was a segregated restaurant. Okay. Thank you, Stuart.
Right.
I heard they serve white collar customers. Just strike out collar. I think that would have been a more accurate statement. They serve white customers. It was a restaurant in Birmingham. They have black waiters. They have black staff. They have black cooks in the kitchen. But they would not have a lot of black customers. If you wanted to eat the restaurant, you're African American, you had to go take out food. Okay. Now, who's next on the list? Who's next? Stuart. Victoria, you here?
Hi, that's me.
So, Victoria, what was the connection between Ollie's Barbecue and interstate commerce?
Well, they were located near an interstate, and they had purchased approximately $150,000 worth of food, 46% of which was bought from a local supplier, but the rest was bought interstate.
Okay, so Victoria, let me ask you this question, please. Did this restaurant advertise to out-of-state customers?
No.
Okay. Hello there. Okay.
That's my dad.
Hi, Dad. Bring your dad to work day, right? Did this restaurant in Birmingham even have any out-of-state customers?
No.
Okay. So in what regard, Victoria, was the Heart of Atlanta Motel different from the Ollie's Barbecue?
The Heart of Atlanta Motel, 75% of its customers were from out of state.
Yeah, so do you see a difference in the analysis between the hotel case and the restaurant case?
Yes.
Okay, very good. All right, so thanks, Victoria. So we have these two different institutions in the South, right? We have a hotel that primarily catered to guests from out of state. And I mean, that makes sense. Generally, if you live in Atlanta, you're not staying in a hotel. If you live in Atlanta, you're going to stay in your own place, right? The people who stay in hotels are travelers or visitors, people, tourists or business travelers. But then we have the restaurant, which catered exclusively catered to locals. Now, I know the lower court opinions really are not mentioned in your cases, but in this case, the district court held that the Civil Rights Act could not be extended to this restaurant because it was only local in nature. They don't cater. So the argument that people or commerce doesn't really matter for the local restaurant. Right? Husna, are you here?
I'm here, Professor.
Okay, good, Husna. So what then is the relevant connection, or what we call the hook, between the local restaurant, the barbecue joint, and interstate commerce?
I believe that they said that the items had previously traveled.
Well, what items? You're right. Just be more precise. What items?
The food.
The food.
Yeah.
And what else? What else might a restaurant have that maybe traveled across state lines? What does a restaurant usually use?
Oh, like silverware, plates.
Good. Ovens, right? Utensils. Thank you very much. A sink, right? Dish towels, right? Go to any restaurant. I mean, we're not allowed to anymore. They're open. No, I guess they're open. But, in theory, if you go to a restaurant and you look around, almost everything you see was probably manufactured in another state. And even if something was manufactured in Texas, the raw materials probably came from another state, right? Just as a thought experiment, look around your house and try to think, okay, what here was made in Texas out of materials that were grown in Texas using manufacturing labor only in Texas? My friends, there's not much, right? There's not much in the world that fits that definition. Perhaps the only thing you might think of is you grow seeds and don't use those seeds. Actually, I got those seeds from China. You remember that from a few weeks ago? I randomly got this package of seed from Chunk. What the hell is this? And then became big on the news. I didn't have to do with it. But anyway, unless you get seeds that are local, you have a locally grown vegetable and you take the seeds from that vegetable and you plant it in your soil using your bare hands and no tools, right? And use locally drawn rainwater. Maybe you're beyond Congress's grasp, but not even then. Because we have Roscoe Filburn, who grew wheat in his backyard. And even his local wheat that never went to market could be regulated by commerce. Right? So the reasoning in Katzenbach, the Ollie's barbecue case, is largely consistent with the Wicker v. Filburn case. Right? If your local growing, if your local restaurant in the aggregate has some substantial effects on interstate commerce, then Congress can regulate it. Right? So here, the court didn't even really need to rely on the substantial effects doctrine. They could have, but they didn't need to. What mattered is that they purchased food and other products that had traveled across state lines. They purchased, produce. They purchased meat, herbs and spices, right? Ovens and dishwashing machines, right? Whatever they bought was from other states. And because their business had this connection to interstate commerce, Congress can then regulate this local activity, this local economic activity, which is denying a service to black customers. Therefore, this activity was within the scope of Congress's federal powers. Right? And this case introduces a concept of what's called a jurisdictional hook. A jurisdictional hook. And, what is this? Hook is something that you kind of latch onto. As long as Congress can show that something you use traveled in interstate commerce, Congress can probably regulate you. For example, a federal firearm offense, right? Why is possessing a gun as a felon a crime? Well, that gun traveled interstate commerce. It was manufactured in another state. Therefore, you're possessing a gun that traveled interstate commerce, and we can therefore criminalize the possession of that gun. All right? Almost every federal crime that exists is premised on the Commerce Clause and the Necessary and Proper Clause. How is there federal murder? Are you shooting a bullet across the state line? I guess you can, right? One person's staying in Oklahoma, the other person's in Texas. You fire across the border. I guess it's a federal murder. But generally, if the weapons you use travel in interstate commerce, that's a ground for federal murder. You may have heard in the news there was a case about the Boston Marathon bombing from a couple of years ago. Right? Why was that a federal case? Because the destructive devices they used, those bombs that they used, were traveling in interstate commerce. Right? They bought the pressure cookers online or something to make these explosives. So really, as long as Congress can show some sort of jurisdictional hook, a connection to interstate commerce, the federal government can regulate you. You should be sensing a pattern at this point that the federal power is pretty broad, and there are not many limits on this authority. There'll be some limits next week. We'll talk about, or next class on Wednesday. But Heart of Atlanta and Katzenbach stand for the proposition that there really aren't any meaningful limits. And once you get to the New Deal, all bets are off. Right? Generations of law students came of age thinking that the federal government can enact any regulation of local activity it wants. There's really no limits. And that the state police power and the federal power are basically equivalent. There's nothing Congress can't do. We'll get to some limits next class, but Heart of Atlanta and Katzenbach reaffirm this broad approach, this broad deferential approach to federal power. And there was no dissents here. Everyone agreed. It was unanimous, which perhaps is remarkable, but in hindsight was the understanding of the time. The New Deal knocked out the direct effect test. The New Deal court built up the substantial effects test. The New Deal court built up the aggregation principle. And then when you get to the 1960s, it's simply following the New Deal in the Atlanta case and the Alabama case. Okay. Questions, my friends, on Heart of Atlanta or Katzenbach? Yes, Harrison, go ahead.
Could you say the language that you used for Heart of Atlanta on the means by which Congress, the means to the end? Could you say that again?
Sure. Yeah, it's in your. I think it's highlighted in your supplement, but I'll be happy to read it again. Here's the key sentence: the means chosen by Congress must be reasonably adapted to the end permitted by the Constitution. The means chosen by Congress must be reasonably adapted to the end permitted by the Constitution. Okay, this is an important concept. I'll focus this for a minute because Harrison asked. I'd be happy to. It's what's called means end scrutiny. Means end scrutiny, right? Where courts will see whether a law is valid, and they ask two questions. They'll first ask, what are you trying to accomplish? What are your ends? And the second question is, what are the means you're using to get there, right? In other words, how are you accomplishing your goal? We often hear the expression, do the ends justify the means? You've heard this expression? That's where this comes from. It's not like, that's made up. It's, are the means reasonably suited or reasonably adapted to accomplish those ends? For example, the end in this case was to ensure the free flow of commerce, that people can travel from one state to another. Is that a permissible end by the Constitution? Yes, the Constitution allows Congress to regulate interstate commerce, so the ends are fine. Okay. Now, what are the means chosen? Well, to ensure that commerce people can flow freely, Congress bans local segregation. Is banning segregation in a hotel a reasonable way to ensure that people can move freely from state to state? I think so. Right. I think it's a reasonable means that's adapted to accomplish those ends. So you balance, right? You weigh the means, the ends, and you ask, do the ends justify the means, or do the means justify the ends? Either way you look at it, the answer here is yes. Harrison, does that answer your question a little bit?
It does. Thank you.
Right. We will talk a lot about this means and scrutiny, more than you'll care to even think about. We'll keep going back to it, but this is an important point. Okay. Very good. Now, after class, I'm going to look over your quiz questions from the last two questions. But when you answer these questions, right, why can Congress prohibit segregation? You should be thinking of a couple things, right? You should be thinking of, what is the activity that's being regulated, right? What is the connection to interstate commerce? What is the jurisdictional hook, right? Is it that people are traveling, or that they're using goods that were traveling in commerce? That's the sort of thing you should be putting into your answers. And I want you to think about these sort of concise statements. Not really a rule statement, but a concise statement of why Congress can regulate it. That's what you should start be thinking about. I'll look at you over your answers later. I don't have time to do it right now. Okay. Any questions before we move on to the next topic? Okay. We are moving on now to the next topic, which was South Dakota against Dole. All right. Let's try this question. Question number 4. All right. Which provision in Article 1, Section 8 gives Congress the power to spend money? A, the Spending Clause. B, the Commerce Clause. C, the Necessary and Proper Clause. D, none of the above. All right, I'll see what we do with this one. Stuart, I see your hands up. Is everything okay?
Mine's a short answer response.
Oh,
no,
crap.
that's a choice.
All right, well, just put in A, B, C, or D. I'm sorry. You're right. Lainey asks, can I call the second case Ollie's Barbecue? I prefer Katzenbach and McClung. That's the name of the case. I prefer you. I mean, if you say Ollie's Barbecue, I don't know what you're talking about, but it's Katzenbach is the case. I'm sorry, I put the wrong question type. Hopefully people are more or less capital A, lowercase a, D period of A, none of the above. Okay. You know what? This is too complicated. I'm going to stop it here. I'll just put multiple choice here. Just put A, B, C, D, or E, or A, B, C, or D, and then that'll just make my life easier. Thank you for that, Stuart. Okay, another 10 seconds. All right, stop it here. All right, so who's next? We have Benjamin, are you here?
Yes, sir.
All right, Benjamin. What's your answer here?
I put A, the spending
clause. All right. Could you point me, Benjamin, to where in the Constitution there is a spending clause? Where is it located?
It's Article 1, Section 8, Clause 1.
All right. Can you read it to me?
To lay and collect taxes, duties, impose and exercise, exercises to pay the debts and provide the common defense and general welfare of the United States.
All right. There's a word missing in there that seems very important.
Spending?
Yeah. Does it say anything about spending money?
No, but I would say that to pay debts and provide for the common defense and general welfare of the United States could be very much seen as spending.
Could be seen as spending. Huh. You see what I'm getting at there, don't you, Benjamin?
Sure. Yes, sir.
Is there actually a spending clause in the Constitution?
Well, there is. It's referred to as a spending.
Okay, very good. All right. Thank you, Benjamin. That's very good. I think he caught on to my trick pretty quickly. This is something of a trick question, right? There is no spending clause in the Constitution. Yes, there's a line about paying debts, right? But that means paying debts owed to, for example, governments, right? You owe someone money. Spending money on stuff is not the same thing as paying debts. The answer here is actually not obvious, right? It's not A, because there is no such thing. It's not B, Commerce Clause. The answer is our favorite, right? Our favorite provision in the world. It's the answer to all of life's problems. It's actually necessary and proper, which is not at all obvious. And in fact, most people, don't even... most law professors probably won't even get this one right. And I don't say that pejorative because they don't think about it. But what actually gives Congress power to spend is really necessary and proper, right? Because there's no express power. Now, how do we know this to be the case? Very early in our republic's history, we had a debate over Congress's power to spend money. Okay. You had Alexander Hamilton on one side, and you had James Madison on the other side. Now, I want you to look at the text of the spending clause very carefully. It's on the lesson plan. It's in your book. I'm going to highlight it on the class notes. It says Congress has the power to lay and collect taxes, do blah blah blah, provide for the common defense, the general welfare of the United States. Okay, what does that mean? Provide for the common defense and general welfare of the United States. Hamilton looked at that language and said, Congress can spend money on whatever it wants, so long as that money is spent on the general welfare. Right? That's the purpose. And that phrase can mean just about anything. What's in the general welfare? Anything. They spend money whenever they want. Madison took a more narrow view. He argued that Congress could only spend money to execute another enumerated power. Right? In other words, Congress could spend money on regulating commerce. Congress could spend money on establishing post offices. Congress could spend money on establishing federal courts. Now, whether Hamilton or Madison's right as an original matter doesn't really matter for us, unfortunately, because the Supreme Court agreed with Hamilton during the New Deal. The Supreme Court said that Hamilton was right, that Congress can spend money on really anything in the general welfare, still though relying on necessary and proper power. Now, why does this matter for our class? Well, we all know the expression, there's no such thing as a free lunch, right? You know the expression? When someone offers you something for free, there are almost always going to be strings attached to it, right? If I give you something, I probably expect something in return. when the federal government gives you something, they probably expect something in return. And sometimes it's very obvious they expect something in return. That is, when Congress gives money to states, they want the states to do something in return. I give, you give. Dare I say quid pro quo, as the phrase of the day is, right? I do something for you, and you do something for me. That's how government works. It's not dirty. That's generally how government operates. Okay? Now, there's a reason why Congress decides to, I won't say bribe the states, but that's what it looks like. The reason why Congress doesn't just give orders to the states, right? Who am I up to? Lewis, you here?
Yes, sir.
Lewis, why do you think Congress prefers to just give money to the states to get them to do stuff? Why do you think they choose that approach?
Maybe because through the Constitution, they lack the rule to just, make a set rule that's uniform across all the states, because that's their police power.
Good.
So if they offer them money, then that incentivizes them to follow what the federal government actually wants them to do.
Very good. So, Lewis, let me ask you a follow-up question. Could Congress have simply ordered South Dakota to raise their drinking age?
So I actually think, yeah, they could.
That's not correct.
Well, I know it's not correct, but I just think with the spending power, the end of that, it says that but all duties, imposts, and excises shall be uniform throughout the United States. So if the drinking age is 21 in other states...
Do you know what a duty is? You know what a duty is?
I mean, I guess not, because I'm incorrect.
Oh, you're thinking a duty is like a responsibility or an obligation?
Yeah.
Oh, that's actually good. No, a duty is a tax.
Okay.
Like, you ever go to an airport and you have like a duty-free store where they don't charge taxes?
Yeah, it's usually like the liquor store.
Yeah, a duty-free liquor store, right. So the phrase in the Constitution that you have to perform uniform duties means that the taxes have to be uniform. Any tax Congress assesses must be uniform throughout the state.
Okay.
So that a duty, I see what you're saying. A duty is not like an obligation, it's a tax. That's good.
Then no, Congress cannot force them to have a drinking age of 21.
I've never heard that before. That's very good. I appreciate what you did. I mean, I think you actually were reading the text carefully. You didn't know what one of the words meant, but that's actually very good. That's good. I've been teaching this class for years. I always get new arguments. That's very good. All right. So I think you're correct, Lewis, that there is no power of Congress to force South Dakota to raise their drinking age. We have another case involving beer in Oklahoma. That's why I got it confused in my head. There's a lot of cases involving alcohol. You'd be surprised. A lot of alcohol cases. It was a huge issue for many years. Now it doesn't matter nearly as much. Okay. So we start from the premise that Congress cannot force a state to raise its drinking age. Okay? But that's not what happened in this case. Congress didn't force the state to raise the drinking age. Right? Instead, Chris, you here? You here, Chris? Going once? Twice? Dina, are you here?
Yeah.
Dina, how did Congress go about getting South Dakota to raise its drinking age in this case?
They enacted a law which allowed it directed the Secretary of Transportation to withhold a percentage of highway funding for any state that had a drinking age below 21.
Ah. How much money were they withholding?
It was...
Was it a lot?
No. I don't actually see an amount anywhere.
It was a very small amount. It was not a huge amount. But,
Yeah.
Okay. All right. Thank you, Dina. So here's the racket, right? Congress offers these states this lovely highway money, which they can use for whatever purpose. I'm sorry, they can use for whatever purpose Congress wants, right? It's a very specific purpose to build highways, to pave the roads, to impose those little barriers on the side, whatever it is. And then Congress comes along and says, wow, you like this money, don't you? You've come to rely on it, haven't you? It'd be a shame if you lost this money, wouldn't it be? It'd be the saddest thing in the world if you lost this money. So, do you want to keep your money? If you don't want this money, you don't have to keep it. We'll be happy to take it away from you. And by the way, those roads don't pave themselves. Those potholes don't fill themselves. And if you don't take this federal money, guess what? You have to tax your people, right? You have to raise local taxes. So, South Dakota, you don't really want to have to bother the people in your state with this money. Just do whatever we tell you. Just help, lend a hand, and help us deal with this problem of drunk driving. By the way, drunk driving today is not what the issue was 30 years ago. 30 years ago, it was completely acceptable to drive buzzed, as you would say. It was just, it was normal. That's what people would do. There was not the sort of stigma against drunk driving that exists today. So it was a very different world than that existed many years ago. So, look, Oklahoma, South Dakota, just raise your drinking age to 21. And we'll be happy to give you all this lovely highway funding, and then no one will worry. It's great. Most states went along with this, but South Dakota didn't. Right? South Dakota did not go along with this regime. Harrison, you're back. Harrison, why did South Dakota not go along with this scheme?
They said that it wasn't sufficiently connected in achieving.
You're right. You're giving me the legal argument, but why do you think South Dakota objected in general?
They said it was unconstitutional.
No, well, duh. Right? Yeah, of course. But why did they decide to go to court of this? Why did they object? What bothered them about this law? You're giving me all good answers, but just. There's lots of things that are unconstitutional. You don't sue over everything. Why did South Dakota sue over this law?
I think they felt it was a little bit more stick than carrot than they were comfortable with. I know that's kind of vague, but...
No. I like that, actually. It's more stick than carrot. What was this law... What effect would this law have on the South Dakota government? What would they have to do?
They would have to change their drinking age from 18 to 21, and they would have to change a regulation in another aspect of
did the state
what they govern.
Did the state want to do this?
No.
How do we know that?
Well, I guess we don't, actually. I think it was more that they didn't want the federal government telling them what to do about other aspects of...
Why? Why did South Dakota not want the feds telling them what to do? That's the key question. Why?
I have to be the 10th Amendment, maybe, or...
Oh, that's a start. What does the 10th Amendment have to do with it?
That states have rights to govern within their own...
Yes. What do you call that? The power of the states to govern their own authorities.
Sovereignty?
Blank power. Fill in the blank. What's that power called the states have?
I'm blanking a little bit.
It's okay. Morgan, what's that power called?
Police power?
Yes. Very good. Thank you, Morgan. Why was South Dakota so upset here? What was bothering them?
Me?
Yeah, Morgan, go ahead.
they were upset because I think they saw this as, like, if the federal government can do this and, like, infringe on this police power, then it opens the door for them to infringe on other police powers.
Yeah, very good, very good. Thank you, Morgan. They were worried about the feds intruding on their police power, right? The feds couldn't force them to raise the drinking age, but they could achieve the same result indirectly by virtue of the spending power. And by the way, I'm saying spending power. I will not say spending clause because no such clause exists. You'll see it. You'll see people say the spending clause. That's not a thing. Right? There's no spending clause in the Constitution. I've read it many times. It's not there. It's maybe it was like invisible ink, maybe, but I haven't seen it. Okay. All right. That's why they brought this suit. Okay, so the majority opinion is by Chief Justice William Rehnquist. And Chief Justice Rehnquist finds that this spending program is valid. It's valid. And the court identifies 4 restrictions on the spending power. Okay, 4 restrictions. In other words, when Congress is giving money to the states, there are certain limits. And those limits are designed to ensure that the state's sovereignty, that the state's police power is not abused. Right? There are 4 general restrictions on the state spending power. Again, this only applies when Congress is giving money to the states. If Congress is giving money to individuals, this doesn't matter. If Congress is giving money to foreign states, this doesn't matter. This only matters when Congress is giving money to the states. Okay, so the first factor is from Hamilton. The exercise of the spending power must be in pursuit of the general welfare. The exercise of the spending power must be in pursuit of the general welfare. Okay, what's the general welfare here? Reducing drunk driving. Right? That seems to be in the general welfare. That seems like a good idea, to have fewer drunk drivers on the road. The second factor is easy to state but proves very important litigation. The condition must be clear. It must be unambiguous. The states need to know what they're getting themselves into. Right? As to say, if you do X, here's what's going to happen. If you do Y, here's what's going to happen. You'll lose $1.2 million, right? The condition must be unambiguous, right? The states have to know the consequences for saying no. It can't be, well, if you turn down this money, a bad thing will happen to you. That's not going to cut it. You need to have more precision. The third factor is significant, and it will be the disagreement point between the majority and the dissent. The third factor looks at how closely related the money being spent is to the goal to be achieved, right? The relationship between the money being spent and your goal. If this sounds familiar, it should. This is means-end scrutiny. It's the same exact issue we keep talking about over and over again. Right? What are the means and what are the ends? So I think, Jose, are you next? Are you here, Jose? I saw you in the chat. Oh, yeah, there you are. So, Jose, let's just repeat. What is the end here, right? What is the goal Congress is trying to achieve?
They want to raise the drinking age in South Dakota.
Well, no, I mean, well, that's actually the means. But what's the end they're trying to achieve?
Oh, I guess safer interstate travel.
Yeah, good. And I don't want to pick on you, but I think you made a very common mistake. People often confuse the what and the why, right? Right? Why are they doing this? They want to make travel safer. right? So what are they actually doing? Now, what do the means, Jose?
The means are to raise the drinking age.
Okay, now let's be precise. Is Congress raising the drinking age here?
No.
What is Congress actually doing?
Well, South Dakota's argument would be that they're commandeering them.
No. What is the federal law actually doing? Just be precise here.
It's restricting funds.
It's limiting highway construction funds, right? Okay, so Jose, bring it together. The means is limiting highway construction funds, and the end is trying to reduce drunk driving. What is the connection? What is the fit between those means and the ends?
That if there's less young people drinking and driving, then roads and highways will be safer.
Right, but what's the I think you're inverting it. I think I see what you did, right? How does withholding highway funds reduce drunk driving?
Sure, I don't want to give you the same answer. I think if you reduce highway funds, then you pressure the state to raise.
Yeah, okay. You're doing a good job. Jose, is there actually a relationship is there actually like a logical link between reducing highway funds and making roads safer?
It's not necessarily direct.
No, in fact, I think it's the opposite. If you have roads that aren't paved, you'll probably have more accidents, right? Just think about it, right? If South Dakota doesn't pave their highways, you get more damn accidents in the highway. Everyone see that point, right? Now, Moses, are you here?
Yes.
Moses, does the majority require any sort of logical connection between the means and the ends?
According to Justice O'Connor, no. They don't require a logical connection.
Good.
Where she's looking for a logical connection.
Okay, well, you brought up O'Connor. We'll jump ahead to her. How does Justice Sandra Day O'Connor, address this third element in her analysis for dissent?
In her dissent, let me get to it. She's going to say that she's going to make the argument that raising the drinking age is not sufficiently related to highway construction, and that this opens the floodgates for Congress just to try to regulate everything, and somehow she actually brings back in the Commerce Clause indirectly.
Well, let me focus on something you said before, right? O'Connor says that the establishment of the drinking age is not really related to this highway construction, right?
Yes.
What, Moses? Let's just have a hypothetical, right? What might be what could Congress do that's better, right? What's a closer fit between reducing drunk driving and federal money? What might be an example of something that would fit the O'Connor test? That's not in the case, but just, what would make Justice O'Connor happy? What kind of federal spending program?
Probably I want to say DARE. I mean, that's what I want to say.
Oh, that's good. But what's DARE? I don't. Is that still a thing? They still have that?
I don't think they still have. It's talked about anymore. But yeah, I was of the age of DARE.
Yeah, me too.
So O'Connor would say, establish a program to educate folks about drinking and driving.
Oh, very good. Yeah, underage drinking driving. Yeah. If you guys don't know what DARE was, it was like it was in the 90s, right? It was a thing that would encourage kids to not drink and do drugs. And is that? I don't know. It's still a thing. I have no idea.
No, that's about right.
Yeah.
I went to college just after Iowa had changed. A few years after Iowa had changed its drinking laws based on this very thing.
Yeah.
Instead of talk of campus.
Oh yeah, I'm sure it was very popular. I mean, let me go on a little soapbox bit here, but the perverse irony of raising the drinking age is you make kids drink in private, right? I mean, where is it safer for kids to drink, in a bar or in a frat house basement? Raising the drinking age to 21 did very little to actually minimize drinking from 18 to 21. In fact, it kind of incentivized it that, oh my God, we got a beer, got to drink the entire thing now, versus you go to a bar and you have a beer and it's normal. So I think there's actually, like most things, there are unintended consequences. So these laws may actually increase drunk driving because people are more likely to drink a lot, they're more likely to travel to get beer, more likely people buy beer for them. So these are largely counterproductive measures, but anyway, not the point of today's class. But O'Connor, I think Moses says quite correctly, is looking for a connection between the means and the ends. It's not enough that they're just related. There has to be some sort of close relationship, right? In other words, the money being spent is on like asphalt and paint and steel for the barriers inside the road. That's not money being spent to reduce drunk driving. So maybe the federal government gives money for establishing police checkpoints. Maybe that sounds a little bit better, right? Maybe the federal government's giving money to buy, those breathalyzers that you breathe into and it measures your blood alcohol content. Maybe the feds are giving money for training to police to detect drunk driving because you swerve in a certain way. There's ways you can detect that from a checkpoint. There are lots of things Congress could do, but this is not it, right? The highway construction funds is so far removed from drunk driving that there's not enough of a connection. But O'Connor was in dissent in this one. Right? Oh yes, thank you, Catherine. DARE, Drug Abuse Resistance Education. I remember that when I was a kid. But anyway, every year I get older. What's that?
It was MAD then, not DARE. MAD.
MAD also. That's Mothers Against Drunk Driving. Right, that's the other one. They were pushing this, by the way. This South Dakota v. Dole. They were very active. MAD used to be. Remember they had the ribbons everywhere. Right, they had yeah. Anyway, I date myself. Okay. But the third element O'Connor dissented on. And O'Connor said you need to have a more narrow test for what's called relatedness. Relatedness, right? The relationship between the means and the ends. You also see a synonym for related, which is germane. Germane, germane. Related and germane are synonyms. They're the same thing. Right? It's like, what's the connection between the means and the ends? And much of what we do in this class is sad students against destructive decisions. Oy vey. I haven't heard that one. Much of what we'll do in this class is figuring out the connection between the means and the ends, right? How close of a fit is required. And the closer the fit, the harder it is for the government to achieve. If it's just, spending money on the highway, cars from the highway, people drive drunk, whatever, potato, potato, tomato, tomato, throw the whole thing off, it doesn't matter, right? That's the majority. That's the sort of approach using Katzenbach. It doesn't matter if anyone actually goes to the restaurant, the food was in interstate commerce. We're here, O'Connor saying, no, you need more than that. You can't just have the food going to a restaurant. You can't just have, this little connection. You need to have more. And in all these cases, you'll see some justices want a very tight connection, and other justices are okay with a loose connection. Deferential versus non-deferential. You'll see this over and over again. All right, questions on the third element. The third element, unfortunately, or depending how you look at it, it doesn't really have any juice. Yes, Lainey, go ahead.
Well, that's what I was going to say. In this case, the majority says loose connection is good enough.
Yep, that's right. It. So under a prevailing law, the third element really doesn't have much relevance. Okay. Answer your question? Okay, I'll assume yes. All right, there's a fourth element, which I don't want you to have to focus on too long. But there's something called the 21st Amendment. The 21st Amendment repealed prohibition. But the 21st Amendment also gave the states power to regulate alcohol. And there was an argument here that the 21st Amendment ensures that the state can set whatever drinking age they want. The court rejects that, saying that it's not an independent bar to giving this money. So don't worry about the fourth element. It almost never matters. But I do want to focus on the fifth element, which does become important. Chief Justice Rehnquist identified a fifth factor. Let me read it to you. He says, a condition becomes unconstitutional when the financial inducement offered by Congress might be so coercive as to pass the point at which pressure turns into compulsion. I'll read it to you again. A condition becomes unconstitutional when the financial inducement offered by Congress might be so coercive as to pass the point at which pressure turns into compulsion. What does that mean? When Congress dangles money, the amount matters. Here we're talking about 5% of highway funds. You know, it would be a burden for South Dakota to lose it, but it's just relatively mild encouragement. But what if the federal government threatened to bankrupt a state and, take away, hundreds of millions of dollars in healthcare funding? Oh, people can't say no to that, right? If you're threatening to withhold so much money, there's not a meaningful choice. This fifth factor would end up making a huge difference in the Affordable Care Act case, NFIB versus Sebelius. We'll study in about a week or so. But this fifth factor wasn't violated here because the amount was so little. But Rehnquist laid down this principle that if the amount withheld is so significant, if pressure turns into compulsion, that is, you can't really say no, there's a violation of the spending power. This is like from The Godfather, right? I'll make you an offer you can't refuse, right? If the offer is so significant that you can't really refuse, then there's no free will, there's no choice. And if there's no choice, then you have compulsion. Then you have coercion, is the word that Rehnquist uses. And if a spending program is coercive against the state, then the spending program is inconsistent with the spending power and it's unconstitutional. Congress would only find ever one law that violated this provision, which was the Obamacare decision, which we'll talk about next week. Okay. I'm going to turn on the short answer, the minute poll, and I'll now ask if anyone has any questions or things that are on your mind. Yes, Laura, go ahead.
I was looking at the syllabus for next week, and we don't have class on next Monday, right?
That's Labor Day, right?
Right.
That's correct.
So then the affordable care will just move down to the 9th.
If that's what it says, that's it. Yeah.
Okay, I'm just making sure I was.
I never know what day of the week it is. Yeah. With no class on Labor Day, the Affordable Care Act's on the 9th, so next class, a week from Wednesday. That's right.
Thank you.
I've had to adjust your syllabus in a few ways to stretch things out because of our glorious hour and 40-minute classes. So unfortunately, we're not exactly where it would be. I usually teach the New Deal cases and the Warren Court cases in the same day, but I had to break it up. We just can't do it all. Glorious schedule. All right, other questions? All right, let me summarize a bit and I'll let you get out of here. We'll return next class to implied powers. This discussion of the spending clause is sort of like a brief detour, a frolic, if you will, because it's not really about implied powers, but it is. The spending power is premised on the necessary and proper clause. And what we've seen in the 20th century is greater deference to the necessary and proper clause that allowed Congress to regulate local activity in cases like Katzenbach and Heart of Atlanta. And we also saw that the Necessary and Proper Clause give Congress the power to regulate states indirectly and encourage them to take actions that are in the federal interest. And throughout this entire period, consistently, the state sovereignty is sort of put on the back burner, and the focus has always been on expanding federal power. Our readings for next class sort of reverse that trend. We'll have a couple cases from the 1990s and early 2000s where the court suggests that there are limits on the federal power. But we'll see those limits were pretty short in duration. And things today are not particularly different than they were 30 years ago. All right. Anything else? Any other questions? All right. I will sign off here, and I'll do office hours in about 10 minutes or so, 15 minutes, and I look forward to chatting with you. All right. Thank you all so much.